Because, Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it an
understand? Sir,
ORB.
your objections mean shit to me. So you keep saying, I object, I object, I object. I don't care. I don't care what you're objecting to. I'm going to hold you in contempt the next time you cut her off.
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying. I object to the
You
denying.
can't object. You can appeal. Brother, why'd you just waste 5 minutes of my life? You got a motion filed?
Yeah, oh, yes, absolutely. I actually have issues to discuss before I cross.
But the court reporter needs to take you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress. I'll cross.
You're under duress? How are you under duress?
Well, Your Honor, as stated in my motion, there's actually fraudulent word that was since unsigned by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother, wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front text up here.
That's fine. Just make sure you're talking to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying to be dismissed.
Which one do you want to start with first?
Well, the recent one I filed, the motion to reject swearing in and all that, based off the fact that, like I said, I was sent a default motion that, I don't know how it even got sent out past it, but it was never signed or anything. I was also defaulted out the fact that there was a citation. I never even presented a court appearance.
Okay, hold on. You're giving me too many issues. You're talking about swearing in, you're talking about a default judgment. Just pick one issue. We're going to deal with them one at a time. So what do you want to deal with first?
Well, my main motion. Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting set
that's the only
aside, so
civil infraction.
I have numerous, I have lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking about that charge.
Yes, right.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled. I went back looking at the citation. There was no date. And actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
Hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy of the ticket.
I said it's in there. It's attached to my motions.
Okay. Do you have a copy of the ticket?
I do.
Okay. Then I'm going to ask you to look at that copy of the ticket. Because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date. Where it says appearance date on or before, there's nothing.
Okay, but it says contact court for appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets, it says if you fail to contact court within the specified amount of time. There was no specified amount of time on here. I had no idea what I was supposed to contact court. I was dealing with trying to get my attorney.
Let me ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame to contact the court.
Mr. Purcell, this is going to go a lot easier on everybody if you just answer the question I asked. I'm going to give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that, actually, when I was defaulted, Your Honor.
Less than that.
Today we're looking at a sovereign citizen who tried to outsmart the judge with made-up legal arguments. However, the judge calmly and logically shut everything down. In court, facts and actual law matter, not personal theories. Let's break it down and see how it played out.
From what?
From whatever this was issued. And like I said, I was contacting
Well, once again, I'm going to draw your attention to the ticket. Ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay? So that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
Well, did you make a note when you received it?
This said I don't remember exactly what date I received this in the mail, but this was scheduled for March 8th.
Okay.
So that was even less than
But what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying I needed to pay bond and an warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice
Well,
of any
well,
sort of.
Once again,
appearance.
you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said, you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay,
There was no dates.
okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when we were in the Honorable Judge Martin. She did set aside the default in the civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir, do
aside.
not interrupt the lady. Did she interrupt you?
No,
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
which I object to that because there's.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I object
No,
to
no,
this.
no, no, wait, listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Not, listen, okay, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly he's threatening me to
No,
issue
no, no.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
But the fact that I was threatened to come in and pay money or warrants. would
How
be
was that
issued for my
damage?
arrest. And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money or I would have been, they'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside. And Judge Green never said a
But
word to me
stop.
about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's but that, especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside that there's no issues.
She didn't try to set it aside, she sat it
But she
aside.
can't. She can't just set my rights aside.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
I don't
No, she never did. No one did. I
Sir.
explained in my motions.
Sir, I'm gonna hold you in contempt the next time you come. The first contempt's $100. The second contempt's a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm, the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right? So we started with, what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care
some point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
You have, hold on, let me just cut to the chase. You have more than just the fact that you think you have a right to travel.
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions you can appeal.
absolutely.
Okay, hold on. I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying. I object to the
You
denying.
can't
of my motion.
object. You can appeal.
Okay. Well, I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
That's absolutely, well, honestly, Your Honor, like I said, I even have both lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about a lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was unlawful stop from the get. I was
Okay, but that's got nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a stop?
Absolutely.
Then make the argument.
Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station in town, and we are in Sibley and Middlebelt, right near actually where I got pulled over. And we had discussed it and talked about it and went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights, I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies. Right, I gave him that opportunity. It was shortly after that, and I had that confirmation well prior to me even being pulled over. Okay, so then this officer seen me leaving my house, pulling off my dead-end dirt road, proceeded, and like I said, I even told him, I've already had this day, I've already used this, you need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me, and wouldn't identify himself, none of that good stuff, and then now this is where it's all led to. And I informed him, I have body.
The defendant kept interrupting instead of simply answering the judge's question. The judge was trying to determine whether he intentionally missed his court date or genuinely didn't know about it. Instead of giving a clear answer, he argued repeatedly, which only made his situation worse.
And I have my own recording. Like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay? And then you went on to tell me how there was obviously a difference of opinion within the department about whether or not what you were doing was legal or not.
Well,
Is that a fair summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to let the prosecutor explain her position on probable cause.
That's it.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his newest motion.
Okay.
Because people submit that the investigatory stop exception in Terry v. Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township Ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right-of-way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, the defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right.
Which I object to the.
Hold on. All right, so the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay. All right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating.
It seemed like the defendant relied more on internet theories than real legal knowledge. In reality, the courtroom operates on established law, not personal interpretations. Basic understanding of the law is important, but misinformation can seriously damage someone's case.
In traveling, as you define operating, or as you define traveling, we define it operating. So
Right.
hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes
with
or
that.
no? Mr.
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reasons?
Yes, I actually, because Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it an
understand? Sir,
ORV.
your objections mean shit to me. I don't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object, I object, I object. I don't care. All right? It's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop you. Do you have any other reasons why you think these matters should be dismissed today?
Yes, absolutely. First off, they're trying to label my private property as an ORV. It was not an ORV, and it's not even technically an ORV. If you look up the definition of ORV, it is not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand
I don't
that.
think it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on is why it should be dismissed? It being these files.
Like I said, from the beginning, it was like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
witness to that as
Mr.
well.
Purcell, with
So
respect,
again,
with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
well,
Right?
the officer chose to retaliate against me is what happened, Your Honor. Which I have the evidence and I have witnesses going on.
Or he had a difference of opinion about whether or not you were driving an ORV.
Or just didn't understand the laws or
That
the
could be
actual
too.
wording.
That could be too. But guess who gets to make those decisions? At trial.
Well, honestly, in a trial, I'd request a jury trial, which is guaranteed.
Well, you can't get a jury trial on the civil infraction, but you can certainly get a jury trial on the misdemeanors.
Absolutely.
Okay. Do you have anything else to be discussed today on motion day?
Well, yeah, and as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own
But sir,
recording.
stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you, I'm going to hear from the officer that wrote the ticket, and then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial, no testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess best no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, it's fine. I will.
File your
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. All right. Now, Mr. Purcell, I'm going to strongly suggest that you get an attorney involved in this. And we've got court-appointed attorneys, so we'll be happy to talk to you from this standpoint. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
I understand, Your Honor.
You don't.
Oh,
You might say that. You don't understand the rules.
I do.
Okay? How many jury trials have you had?
None, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against, and you don't. I'm going to suggest to you that even if you want to handle your evidence presentation yourself, you might want to get an attorney involved to help you with the procedural rules, because once again, I'm not going to take you to law school that day. I'm not going to subject the jury to that. It would be a waste of their time. You understand that? All right. Now, and I'm not trying to talk you out of a jury trial. Believe it or not, I'm trying to save you from yourself right now. If you want to have a bench trial, I will be much more lenient with you not knowing what you're doing procedurally, because then it's just our time. But when it's a jury in here, I'm going to run the most efficient jury trial I can, and that means I'm going to treat you like you're an experienced lawyer and know all the rules.
Okay.
All right?
All right.
So if you decide, number one, that you don't want a jury trial, you want to do a bench trial, let me know long in advance of that date so we can save it for somebody else. Or two, if you want the assistance of an attorney, I will give you the ability to talk to one of our court-appointed attorneys and see if they can assist you in the manner you want to be assisted.
Okay.
Understood?
Yes, Your Honor.
Any questions?
Nope.
Anything else?
Not the Honor.
Have a nice day.
Thank you.
The judge handled the situation professionally, calm, firm, and focused. Court time and taxpayer money shouldn't be wasted on baseless arguments. Different opinions from officers don't override the law. If you don't have the proper license or documentation, you are still breaking the law.